party has been fully heard on an issue during a jury trial, and the court finds that a reasonable jury would not have a legally sufficient evidentiary basis to find for the party on that issue. I address in particular, some of this argument predates us, but it's good to kind of bring us up to speed, I think. At one time, the plaintiff pursued both a negligence claim and a negligent infliction of emotional distress with punitive damages claim. The court heard all arguments on that and granted Paltrow's motion on the second claim, negligent infliction of emotional distress and punitive damages. At that time, the court made some findings. I have that ruling in front of me, dated August 2, 2021. Excuse me. The undisputed facts do not support the assertion that Ms. Paltrow committed a hit and run, among other findings. When we came to court 8 days ago, seems like 8 months ago, the court said, the plaintiff said, we're still asserting a negligence claim after the collision. I brought this to the court's attention, and Your Honor, we looked at the complaint, which only asserts negligence up to the ski collision. And you said under general pleading standards, I'm going to hear evidence of it. We've now heard evidence. I believe no one has testified, and I know Your Honor asked us to marshal the evidence that would show it for the other side. So I have racked my brain on anyone saying that there was a breach of care, breach of a duty for Ms. Paltrow to not provide information and stick around longer. There has been some reference to the skier's responsibility code that has a sentence in there to that extent. Ms. Paltrow testified that she left only after a designated Deer Valley representative said, you can go. I think the undisputed testimony is that Mr. Erickson told Ramon, I guess who was in better mental shape, who she was. Your buddy just took out Gwyneth Paltrow. And we know that Mr. Sanderson was aware of the name because by 9 p.m. he's texting that he's famous. And he's famous because he knew that he had collided with Gwyneth Paltrow. So I don't see any evidence that, or any testimony from any expert or witness, fact witness, that there was a breach of that duty. Then moving to damages, one has to prove not just that there was a breach of a duty, but that it caused damages. I've heard zero testimony on that issue. And in fact, they did learn who it was. So a classic hit and run is someone just hurt me and left. I don't know who that person is. It's a phantom skier. That was never the case here. Whitney was the toboggan person from Deer Valley. She recalls hearing from Ramon, it was Gwyneth Paltrow, it was Gwyneth Paltrow, it was Gwyneth Paltrow. So I don't think the plaintiff has made their case on that, and I request directed verdict. On a somewhat broader issue, the issue of negligence generally, which would throw out the whole case. the case law in Utah, as I read it, which I acknowledge may be overly optimistic, but that two skiers can collide without one of them being negligent. This has been the subject of one of my jury instructions. I don't believe I've heard anyone testify that they saw Ms. Paltrow skiing negligently before the collision. The 3 or so skier on skier collision cases, as I read them, requires something more than because of the implied risks of skiing. Unlike, for instance, a car accident where someone has to be at fault, I think skiing is different. When we strap on sticks on our feet and go down a slippery slope, the implied risks, including specifically collision with other skiers, they need something more. I acknowledge the testimony of Mr. Bogger, who said if Gwyneth's story is accurate, there was a breach by Sanderson, and he was asked the cross question, which was if Sanderson's story is correct, then Gwyneth breached the skier code. So I acknowledge that's out there. On its face, that sounds like, that's a classic jury question. But I think there's still a dearth of testimony about no one saw her skiing negligently, certainly not recklessly or dangerously. I think the most they have is Carrie Oakes. We read part of that transcript of this idea that somehow at the top of the lift, Moses and or Apple were saying, "Hey, Mom, we want you to watch us." That, I think, is the most. Now, it's funny, if you caught this from reading those kids' depositions, Moses says, "I don't remember saying that." Apple says, "I don't remember saying that." Gwyneth says, "I don't remember saying that." But Carrie Oakes said something to the effect that at some point they did. Now, I think there was a specific question, hey, was that just before the collision? And I remember her testimony as saying no. I mean, it was sort of this generic thing. It wasn't close in time. With that, I think it's appropriate to remove these issues from the jury. Thank you.
Thank you.
Good morning, Judge. I assume you've read our brief that was filed early this morning.
I did.
So I'd just like to add a few points in addition to that. Terry's own testimony supports negligence claim against Gwyneth Paltrow. It's never changed. He said he heard a scream and then he was hit and he was out. This is corroborated many times by Craig Ramone, the only eyewitness who saw it a few seconds before the impact. He heard the scream and then turned over and saw Gwyneth Paltrow ski into the backside of Terry. It was a hard enough hit that it knocked him down and gave him 4 broken ribs and a concussion. That's very clear. That's causation and damages. Craig Ramone said that Gwyneth Paltrow never talked with anyone at the scene. There's, of course, disputed testimony that she swore at Terry at the scene. In either case, it shows negligence afterwards because it delayed the summoning of ski patrol because Craig Ramone said he was shocked or stunned that what's going on here, and then next thing you know, everyone leaves and he's there alone with Terry Sanderson.
So what's the evidence, as pointed out by the defendant in their briefing, what's the evidence that delay in treatment, and we get this in a medical malpractice case where there's an allegation that diagnosis was delayed negligently, and there always has to be medical evidence to support damages during that delay period.
The delay, well, there was...
What were your client's damages during, if it was delayed, what were your client's damages?
At least $1, Your Honor, worth of damages. He was frightened. There's evidence from Craig Ramon that he was frightened. Terry Sanderson testified he was frightened, and that added to his mental anguish, compounding his mental health injuries.
But fright doesn't support a negligence claim, does it?
It may just be worth $1 or more, but
no. But my question is,
it does support a negligence claim.
Isn't that what negligent infliction of emotional distress claim is all about? Whether fright can be recovered, and that has already been evaluated by the court.
It has been, but then we're focusing not on NIED. We're focusing on the delay in treatment, the delay in summoning the ski patrol.
But the only damage that you can point to is fright.
Well, there's fright and the delay, and the fact that.
Let me ask you the secondary question. I'd like you to comment on: can she recover for that anyway under the negligence claim?
Can he or she?
Can't your client
can
recover for that fright, or I assume under the jury instruction that would be mental anguish?
Yes.
Under the non-economic damages jury instruction. So can't you recover for that anyway? What does this give you, this post-accident conduct give you that you don't already have?
In comparison to the permanent brain injury, it's small, but it gives us additional damage that continues afterwards because...
And why can't you argue that damage anyway?
Well, we can, but it seems like the defense wants to cut off all evidence because of the motion for summary judgment on negligent infliction of emotional distress, but that only says that claim is gone, which has a different standard than normal negligence.
Correct.
So we're arguing that standard negligence applies here for what happened after the crash. We also have the violation of the Skiers Code and the Summit County Ordinance, the safety, which requires that the defendant stay on the scene to summon help, give out names. The evidence at trial shows that Terry Sanderson was knocked out and didn't know what happened, and Whitney Smith did not believe Craig Ramon saying, hey, it was Gwyneth Paltrow, and so what happened was he continued to be frightened even up until Whitney Smith took him down in the toboggan, and maybe at the ski first aid station, excuse me, Miss Whitney Smith, the patroller, took care of Terry, and Craig Ramon had said it so many times, finally it dawned on Terry that no, it wasn't me, and he could relax because of that ongoing negligence delayed the treatment. Whitney Smith was not able to properly assess Terry and properly investigate this, properly do the things that a patroller would normally do if Miss Paltrow had hung around. So the damage is, I think, I'm not saying it's as big as the main injury, which is the brain injury. It's not, but the broken ribs were causing pain. Terry was frightful about what had just happened to him. He's waking up from unconsciousness. There's clear testimony to all of that. Craig Ramon says that. Terry Sanderson says that. Craig Ramon confirms it. Even Whitney Smith confirms the disorientation. And even on the log of the ski patrol, it says disorientation.
My question still, though, is I agree with all of that. My question still is, though, if I grant a directed verdict as to liability on these allegations of post-accident, failure to give name and address, failure to render aid, if I grant a directed verdict on those two things, why can't your client still recover for all of that fright, for all of that delay? I mean, isn't that something that you can still argue under?
Oh, yes. We definitely agree with you on that, Your Honor.
So what does it get? What does it give you? I guess this post accident acts or omissions.
I don't think it requires a special instruction. I think it's just the standard negligence. Just like, let's say there's a car crash, and the crash creates an injury. In addition, I'm sorry, I forgot to mention this. This was filed at 9:30 last night. Sam Goldstein testified right there that this delay and denial and caused Terry to suffer additional psychological, as well as not neuropsychological, not brain damage, but psychological or psychiatric injury, where to this day, where Terry is upset, more than upset, but Sam Goldstein, the neuropsychologist, testified that this pattern has caused Terry to continue to suffer damages. It's not brain damage per se, but it's emotional or psychiatric or psychological trauma, not neuropsych. And Sam Goldstein, who's also a psychologist, testified to that, and that it's ongoing to this day on this witness stand right here. And we don't want to compare it to the brain injury, but all combined, it's all those factors combined to support Terry's damage claim for negligence. And we just think that to artificially cut it off at the end of the impact, and when Ms. Paltrow bounces off Terry and slides off and Terry's face down, as the testimony of Craig Ramone confirms, that's not the end of the story. The story continues on and has affected Terry to this day, at least psychologically, and Sam Goldstein confirms that.
Let me get this straight about, so I understand the failure to render aid aspect. And are you relying on the ordinance for that?
Both the ordinance and the ski code, but it's not just the failure to render aid, it's also the... Okay, go ahead.
And then the second question is failing to give name and address. How do you attach that to any damage?
Well, that's like in the car crash, and someone's dazed, concussion, and it may not be a hit and run. It may be something less. They stayed and they said, "Are you okay?" And if we assume they're correct, but they get up, and Craig Ramone says Gwyneth Paltrow didn't say anything. And they just get up and then they drive away.
But the ordinance requires, are you relying on the ordinance for the name and address thing too?
Both of them, but also just common sense. It could be a sidewalk.
What?
It could be a sidewalk, Your Honor.
Both of what? You're relying on both of them, you said? Both
the ski ordinance and the skier's code.
Does the skier code say that you need to give your name and address?
The skier's code, yes.
What's that exhibit, plaintiff's exhibit?
Well, it was testified to by Eric Christensen and I believe by Paul Bogger yesterday that there's a skier's code, and it's also testified to by, it's just kind of, it's standard like...
Mr. Sorensen, do you have the plaintiff's exhibit for that skier code?
Let me look, Your Honor. I don't have it right just a second.
I can look for
Here it
too.
is. It's 37.
Here, it's faster than I am.
Doesn't talk about giving your name and address if there's an impact. So the only evidence that I'm aware of for establishing that as possible evidence of negligence is the ordinance.
I think the ordinance, but also...
And the ordinance says that they're to give it to a Deer Valley employee, and she already had done that before she even started that day. The Deer Valley employees, the ski instructors knew who she was and had her contact information.
But the clear testimony is the ski instructor, Christensen, did not give her information.
But the ordinance doesn't require that.
The ordinance or the skier's code?
Either one.
The
ordinance says that they're to give it to a Deer Valley employee. if there's an accident. Am I reading that right? I think that's Exhibit 38.
Plaintiff's exhibit, Your Honor.
Yeah, at the very end of the Summit County reckless skiing ordinance, the last phrase. If it is necessary to secure aid for a person injured in the collision, the person securing such aid shall give his name and address as required herein after such aid is secured and before leaving the ski area.
Okay.
And that's
And
38.
who's the person securing such aid? I think that's the person that reported it, right? Wouldn't that be Mr. Ramon?
Yeah, it says any skier above the first part of that full sentence of Part C. Skier's duty to notify operator or employee in event of collision. Any skier involved in a collision with another skier or person in which injury results shall give his name and address to an employee of the ski area operator or a member of the ski patrol.
And that's my
before
point.
leaving.
Didn't she do that? Isn't it undisputed that she gave that information to a ski area operator?
It wasn't on the incident report. When my client sought that information, it wasn't listed on. In fact, it was whited out on the information he got, so he had no way to contact her, and he had to spend additional effort, psychological effort that was harmful to him, as per Dr. Goldstein. This continuous denial and obstruction added to his torment and damages. Now, you could say it's wrong, it's small, but Dr. Goldstein said it was significant enough that he reported on it and said Terry Sanderson was still suffering from it 5 years later.
I do understand the argument now.
Thank you, Your Honor.
Mr. Owens, any follow-up?
Thanks, briefly.
None of us wants to confuse the jury. They understand this is a negligence claim. But even I'm confused on this idea of she did something negligently after the fact. There's been no evidence, no expert testimony or otherwise that the delay caused any harm whatsoever.
What about Goldstein's testimony?
So Goldstein's testimony, as I recall, it was Eric Christensen's yelling, not Gwyneth Paltrow's not yelling. He described Mr. Sanderson observing and hearing a man screaming in his face, Eric Christensen. That's disputed by Mr. Christensen, but even if it's assuming it's to be true, that has nothing to do with Gwyneth Paltrow's personal information.
What about the argument that the difficulties encountered later in figuring out who this was and establishing, the correct information from the reporting caused additional, I guess, anguish on the part of Mr. Sanderson?
So Steve Graff, the Deer Valley head of operations, reported receiving 2 contacts from the patient, from Sanderson, and that he responded and relayed Gwyneth's proper information.
I realize that's your evidence, that's the defendant's evidence, but what about the plaintiff's evidence? Could the jury not make some conclusions based on that are reasonable?
So, what do we know is by 6 hours he knew the person's name and actually thought it was cool. I'm famous. And I think the undisputed testimony is that the ski instructor told Ramon, your buddy just took out Gwyneth Paltrow. Now, if Sanderson's testimony is to believe, he wasn't in his best state to receive an address or anything. It was appropriate to talk to his friend. His friend Craig Ramon's right there. That was Gwyneth Paltrow. you can Google Gwyneth Paltrow and get an address for her work. They had that together. Then they were texting on their meetup group, like Gwyneth Paltrow did this. So they had information right away. The mental distress and things, I think, as you said, they can talk about that, the aftermath, but not her actions. She didn't have negligent actions. By, I think in all reports, Terry said, "I'm okay."
What about Terry's testimony and Mr. Goldstein? I guess that's what I'm focusing
Okay,
on, their evidence.
Goldstein's,
Terry says that he was frightened by the fact that he was just left there.
yes.
And Dr. Goldstein substantiates that and substantiates that it was a continuing concern.
Goldstein, and I took it all to mean Christensen. Terry looked up, he saw a Deer Valley person in a green outfit, and he said, "Oh good, there's someone here to help me." And then when the green Deer Valley guy skied away, which is contrary to Eric Christensen's testimony that he was the last on the scene, but let's presume Sanderson's testimony is correct. He felt abandoned. He didn't say, "I felt abandoned that Gwyneth left." I don't remember that testimony. So I think they're conflating the two. It's probably a good thing that Gwyneth didn't stay. She was pretty mad. She got the all clear from Christensen. He's okay. They observed no unconsciousness, by the way. He's on his feet. Ski patrol people, everything okay? Everything's okay. And then you can leave. The abandonment came from the ski employee. And that was for, keep in mind, a few minutes. Because a few minutes later, downhill, "I'm not okay." Okay, different story, but "I'm not okay. Let's flag the patroller." Whitney's there, and so we really are talking about a couple minutes. And it wasn't from the Gwyneth abandonment, it was from the ski patroller. He felt like the ski patroller had bullied him and had abandoned him. He never said, I felt hurt and abandoned and frustrated that the skier, whose name they now knew, had left. That's all. Thank you.
All right. Thank you. Well, I don't want to delay the jury. Let me just rule on these motions. So as to the directed motion on the negligence claim, the general negligence claim for the accident itself, the court denies the motion for the reasons that and the evidence that were marshaled by Mr. Bueller. As to the post-accident conduct, it's a little more difficult, and it's also complicated by the fact that there was a negligent infliction of emotional distress claim that was dismissed, and essentially what the plaintiff is claiming is related to the post-accident conduct, is in the nature of emotional distress or emotional or mental suffering, the fright associated with being left alone, and the fright associated with failure to give name and address. Let me just address that part first. So I don't think there's any evidence that the jury could decide that Ms. Paltrow did not give her name and address to an employee of the ski area operator or a member of the ski patrol before leaving the vicinity. She did do that. So I don't believe that she violated any duty that might be imposed by the ordinance, and that's the only place that there's any evidence that requires her to give her name and address at the scene of an accident. And so that post-conduct, I think, is out. As to the duty to render aid, I think that there is an issue of fact, and there is evidence that the jury could decide that the duty to render aid was not followed. And I'm relying on the plaintiff's testimony himself, as well as that of Sam Goldstein and Mr. Ramon, I think that I acknowledge that that the testimony on this issue was primarily directed at the Deer Valley employee and the fact that they allegedly abandoned the plaintiff at the scene. But I think that there's enough testimony from both the plaintiff, Mr. Ramon, and then also from Sam Goldstein to also include the defendant herself. And I'm not commenting at all on any of the evidence that the defendants have presented on that issue. I'm only focused on what the plaintiff presented because I'm required to do that, and I'm also required to grant them any reasonable inferences from that evidence that the jury might be able to make. So that portion of the motion is denied. I guess what that will leave for us is to determine how to read that ordinance in terms of a jury instruction. So we still have that to resolve after we spoke last night. Any questions or clarifications?
No, Your Honor.
Okay, why don't we just take a short break then, and we'll return with the jury. Thank you. Are there any other preliminary issues? Okay.